My name is Gabe Walsh, and I'm the legal counsel here for the Iowa Association of Realtors. It's been a little bit since we've had one of these legal breakdown videos, so it's great to be back in front of the camera and look forward to seeing you all soon. Today what I want to talk about is effective July 1, 2020, there is a change in one of the exemptions of the Seller Disclosure Code, 558A of the Iowa Code. Now, as you might remember, I wrote an article about this back in November and started this conversation. Now, the change in the Seller Disclosure Code is about the exemption and what I call the trust exemption. What the exemption has always said is you are exempt from having to fill out a seller disclosure if it is a transfer by a fiduciary in the course of the administration of a decedent's estate, guardianship, conservatorship, or trust. And if you remember that November article, and an article actually that I released just today or yesterday, what both those articles talk about is this situation, this idea where a seller has lived in their property, let's just say for the sake of argument, 40 years. They go to sell their property, but their property just so happens to be in their living trust. Is that seller really exempted from having to fill out a seller disclosure statement just for the fact that their property is held in a trust under that exemption? And if you talk to attorneys in the industry, you talk to realtors or other persons in the industry about that exemption, you will get arguments all over the board. Some would have argued under that exemption that a trust is a trust is a trust, and even in that situation, even though that seller has lived there 40 years and has all the knowledge, the exemption says what it says, no disclosure required. Others argued, no, the whole point of the Seller Disclosure Code was to, only exempt situations where the person transferring did not have superior knowledge of the transferee. So there were plenty of arguments that disclosure, in that general question, a disclosure should be provided. So answers were all over the board, and that was concerning. It was concerning that lawyers and realtors and nobody really knew what that exemption exactly meant. So what IAR did is got involved in the legislative process this past session and pushed for clarification on this particular exemption. Effective and applicable July 1st, 2020, the seller disclosure exemption says, exempted is a transfer by a fiduciary in the course of the administration of a decedent's estate, guardianship, conservatorship, or trust, right? That's what it's always said. But it's amended to add to that exemption, this exemption shall not apply to a transfer of real estate in which the fiduciary is a living natural person and was an occupant in possession of the real estate at any time within the 12 consecutive months immediately preceding the date of the transfer. So as you can see, that example where we're talking about somebody being in the house 40 years, they have knowledge, they're living in it, they're selling it. That general situation is what we were trying to fix. That's the problem we were trying to fix. And we believe that this new language and this exemption clarifies that. Now, one thing to note is that although IAR was going at this from the angle of that trust situation, this new language applies equally to trusts, decedent estates, guardianships, and conservatorships. So keep that note in mind. And finally, what I think is really important to keep in mind is this isn't going to fix every situation. This isn't a cure for every possible situation. And a couple other things to keep in mind with seller disclosures. The first is a seller's disclosure is exactly that, right? It's a seller's disclosure of their knowledge of their property. And you as a realtor should not be ever advising on what disclosures a seller should make. And if a seller has a question about this new exemption and how it applies to their situation, again, that's a legal question. Do your job and make sure you refer them to legal counsel to get advice on, what disclosure obligations they might have under this new exemption. But that being said, I think it's also important to keep in mind that as a broker or salesperson, 558A also talks about liability under the chapter. And what it says is a broker or salesperson shall not be liable under this chapter for the error, inaccuracy, or omission in information required in a disclosure statement unless that person has actual knowledge of the inaccuracy or fails to exercise ordinary care in obtaining the information. So look, there might come a time where maybe you're disagreeing with a seller not delivering a disclosure. And again, it's important to keep in mind that you can't advise on what they should disclose, Under the same token, you need to make sure that you are protecting yourself from liability under the chapter. So if you have questions about your liability as a broker, as a realtor, as a salesperson, you need to also seek the advice of an attorney to see what obligations you might have in those situations. So again, talk with legal counsel about this update, but this is certainly a change. And I'd just like to give a special thanks to our lobbyist, Jen Kinglin, our government affairs director, Jamie Horbach, our legislative committee, and a special shout out to realtors all across the state of Iowa who came together to get this passed, because at the end of the day, this was always about the members of the public making sure they have the information they need when they're about to make one of the biggest purchases of their lives. So again, good to be aware of this change, and hope everybody's doing well.